The Fall 2020 Hinkle, Pryor, and Fischer Parent Empowerment Conference. Realities for a New Reality. 2 days, 25 workshops, renowned speakers and presenters, by families, for families, nearly 40 hours of unfiltered and straightforward information, made possible by the leaders in disability rights advocacy for over 45 years, Hinkle, Pryor, and Fischer, attorneys at law. So welcome to this session of our ongoing encore presentation series of the Fall 2020 Hinkle, Pryor, and Fischer Parent Empowerment Conference.
Welcome everybody, and thank you for attending the Hinkle, Pryor, and Fischer Virtual Parent Empowerment Conference. My name is Christina Tosti, and I'll be your moderator for the workshop entitled The Importance of Wills and Trusts in Planning for a Secure Future. Our presenter for this workshop is Paul Pryor, partner at Hinkle, Pryor, and Fischer. Before we begin, we're going to ask all participants to remain muted throughout the session. This workshop will last approximately 90 minutes, and if time allows, the presenter will take questions intermittently throughout the workshop. Please ask your questions through the chat feature in the control bar, and I will ask as many of them as I can, again, time permitting. Now, it's my pleasure to introduce our speaker, Paul Pryor. Paul Pryor spent his entire legal career representing people with disabilities. As the younger brother of a man with autism, he has a lifelong commitment to disability law. His legal work has focused on special education, guardianship, financial entitlements, and access to appropriate services. A substantial part of his practice is devoted to assisting families in estate and trust matters. He has successfully argued leading cases before the New Jersey Supreme Court, Third Circuit Court of Appeals, as well as other state and federal courts. He served as a federal monitor overseeing conditions at state-operated institutions. He holds a JD from Seton Hall University School of Law and serves on the Board of Trustees of the ARC of New Jersey, as well as Eden Autism. He's a member of the Aspen Professional Advisory Board. Previously, he served on the boards of Special Olympics New Jersey, Autism New Jersey, and the Eden Autism Foundation Advisory Committee. He's a member of the Elder Law Section of New Jersey Bar Association. He has testified before the New Jersey Assembly by invitation and has assisted with the development of several pieces of legislation concerning individuals with disabilities. He writes and lectures frequently on topics concerning the law and disability, as well as issues affecting siblings. Paul enjoys listening to live music, running, skiing, and is an avid baseball fan. Now, without further ado, Paul Pryor, please take it away.
Thanks, Christina. And the avid baseball fan, right? That's the most important part of this. You know, go Yankees, right? On Monday, I believe, taking on the Tampa Bay Rays. So at least we got a little bit of baseball in this year. So hi, everybody. Paul Pryor, Hinkle, Pryor, and Fischer. Some of you have probably come over from the workshop that I hosted with Don Brown immediately prior to this one, where I talked about how Don talked about the financial and economic planning of an estate, and I'm talking about the nuts and bolts and some of the other, kind of documentary and practical planning issues regarding wills and trusts and, benefits preservations and all of that good stuff. As I joked over there, he talks about planning with a warm hand, and I talk about planning with a cold hand. So this is the fun side of things. Now, guys, I like to be very informal when I present, and I talk about these issues. It's a little bit stilted, a little bit different, obviously, on Zoom. I do a lot better when we're all in person and all in the same room, but we obviously can't do that right now. So what I will say to you, if you want to turn on your video screen, that's fine. A lot of people hide their video because they think it's distracting to the presenter. I don't. No pressure. If you don't want to share your screen or you don't want to turn on your video, you don't have to. I'm not going to think any less of you. Also, I really do like to ask questions, or I should say answer questions as we go along. So a lot of the presentations and a lot of presenters that do these things, they say save your questions to the end. I'll be probably stopping periodically throughout this to just take questions and ask Christina if there are any questions. Because I don't like to hear myself talk on and on and on about this topic or any topic. And I'm here to try and give you the information that you want to know, not necessarily the information I think you need to know. So I'm very open to taking questions as we move along. All I ask is that you keep your questions basically general questions and not too particular. But, sometimes, specific questions or particular questions can be used as a good example for the group. If they're too specific, I'll let you know, and I'll just make them more broad. So anyway, thanks everybody for being here on day 2 of the Hinkle, Pryor & Fischer Parent Empowerment Conference. I am excited to talk to you about death. Uplifting topic for a Saturday morning for sure. I get people in my office all the time who are talking about these issues, and they say things to me like, if I die, I want to make sure that, my affairs are in order. And if I die, I want to make sure that there's a guardian for my child or children. And if I die, I want to make sure that I don't do anything that inadvertently renders my kid ineligible for government assistance benefits. And about the second or third, if I die, I have to stop folks and I have to say, I'm sorry to be the first one to have to break this to you, but it's not a matter of if, right? It's a matter of when. So, it's a sobering thought to think about, but none of us like to think about, our own mortality. None of us like to think about our own death. But, none of us are getting out of this world alive. So, it's something that you have to confront. People ask me all the time, when is the best time to develop an estate plan for someone? Do I do it when my kid turns 18? Do I, address it when my child goes on benefits? Do I wait till he's 21 and he's out of his educational system, out of the educational system, and questions like that? And, those are common times when parents do come in and talk about these issues because it's a transition point, and has them thinking about these types of issues. But, the real answer is you want to take care of this stuff sometime before you die, right? And if you know when that's going to be, you can back up like 6 to 12 months and then we can get the ball rolling, right? But since none of us know when that's going to be, no, there's no time like the present. And, look, you don't have to be particularly wealthy. You don't have to have a lot of assets. You don't have to wait to accumulate things. You always are worth more dead than alive, and people are generally worth more than they really realize because people don't always remember the values of things like 401ks and IRAs and how much equity they have in their house and things that people own and have, but they forget about because, you look at your checkbook every other Friday and it looks good. And then you look at it every other Monday and it doesn't look as good as it did, at the beginning of the weekend. And you don't think you have a lot, but you really do. And most families, if they do nothing, are going to wind up creating big messes for themselves or their children, I should say, if they fail to plan at all. If you don't remember anything from this workshop, if you don't remember one other thing that I'm about to say, remember this, please. A child with special needs, generally speaking, can have no more than $2,000 in assets in his or her own name from all sources combined, right? If you wind up leaving a child money because you don't have a will or you don't plan properly or you fail to change beneficiary designations on life insurance and so forth, and that child comes into more than $2,000 in assets because of your death, there's going to create problems. And most people have assets that are going to be, greater than that amount, and it's going to screw up benefits. And that's really what we're trying to prevent here. Now, there's a whole lot of other reasons to engage in estate planning and creation of wills and trusts and so forth that have nothing to do with your child with special needs. I mean, that's the focus of our comments today. That's the focus of your life if you're here. That's the focus of our practice. But there's a whole lot of other reasons to engage in these types of planning techniques, because you got to worry about tax considerations. You got to worry about the orderly transition of your affairs and your estate. You got to think about who's going to be in charge of your estate when you're gone. You got to think about who's going to be the guardian of your kid when you're no longer here. If you have neurotypically developing children who are minors, you've got, or young adults, you've got to, address those kinds of issues. So we're going to like touch on most of that today. So generally speaking, when I'm doing these things in person, I talk about, I like to use some examples. And I like to talk about various scenarios that can come up as a way of kind of illustrating things to help drive some points home. Normally, I pick on two people in the crowd, right? And I, make them, like they usually sit in the front row, and they usually regret it, and I usually, use them as my examples. So I don't have the luxury of that today because I'm sitting in my sitting in an empty room, talking to no one in person. But I am going to pick on people, and now you're going to regret on muting your videos. So so I'm going to, let's say that I'm a person, I'm a father. I have two children. Now I'm going to be fair. I am going to take Christina, who's I can pick on, and I'm going to make her, my daughter, my neurotypically developing daughter, and then I'm going to take Jeff Harris there. I'm going to take you, and I'm going to make you my son with special needs for today. Okay, so thanks for unmuting your video. But I've known Jeff, and I like Jeff. Said I think he's got. I know you can take it. So you're my child with special needs for today. So everybody, meet my daughter Christina, meet my son Jeff. Great guy, great children. Raised them well. So now let's say, as a parent, I've acquired some assets over the course of my life. By way of example, let's say that I've got, a home that's worth, $500,000, and I paid it off over time. It's got no mortgage. So I've got that. And let's say I've got some life insurance that, has a death benefit of about $250,000. And let's say that I have some other assets, some retirement assets and some savings and so forth that have accumulated over the years. And that's another $250,000, right? So it's $1 million, easy assets, nice round number to work with. So that's what I've acquired over the course of my lifetime. Now, let's say, by the way of illustration, that I don't have a will, that I don't have any planning documents set up whatsoever, and I die. Who wants to take a crack by putting an answer in the chat feature? Who wants to take a crack at what they think will happen when I die? Where's that money going to go, Christina? What are people saying?
So one person said it goes to the state.
Mm-hmm.
And then we're waiting on anybody else. Hold on.
Goes to the state. That's a very common one. The money's
going to the daughter. Ooh, that's a good one. I like that one.
Don't get too greedy there, Christina.
One person says probate. Another person says 50-50 to children, 50-50 to children. So there's two people that say 2 kids split.
Good.
If your spouse is already gone. Oh, look at that one person through that.
You know what? There's always one.
There's one?
In every crowd. If my spouse is already gone, right? They're so proud of themselves. It goes to your spouse, right? That's a good answer, by the way. It goes to your spouse. That's a very good answer. I will give that person credit, and I'm very sorry I did not. Let me repaint my scenario. Let's say I killed my spouse years ago and got away with it, and like nobody ever found out. Okay, so that's a good point. That is the right answer. It would go to your spouse, generally speaking, but let's take her out of the equation. And then the other answers were the state, the daughter, which is Christina's favorite answer, yeah. 50-50 money. No, it does not go to the state. It will go through probate, but states always go through probate. So that's I give that person, some points for that answer. But everything goes through probate in one way or another, generally speaking. It does not go all to Christina as much as she would. Christina, I'm sure Christina put that answer in the box.
I did not, I
swear. The answer that it goes 50-50 between your kids is, generally speaking, the accurate answer. That's the answer I'm looking for. So for the participants who said that, thanks for that. That is, generally speaking, you know, with some exception, that's the right answer, okay? So, you know, that's fine, right? So it goes equally to my kids. So Christina gets her $500,000, right? And so, again, she's happy. You know, she gets that despite the fact that she, you know, never called me on Sunday, didn't come see me in the nursing home, you know, didn't remember my birthday, you know, so she gets that regardless. So, and then Jeff gets the other half. And the issue is, let's say Jeff has been, is on SSI, let's say he's on Medicaid, let's say by way of example, he's receiving services from DDD, and let's say those services are in the form that Jeff has been living in, let's say for the last 10 years, in a typical suburban-based group home funded by DDD and Medicaid, okay, for the past 10 years. So what people need to know, what you need to understand is, I've now knocked Jeff off of SSI, Medicaid, and any other means tested form of benefits that he has, because the $500,000 he got from me is slightly greater than the $2,000 resource room that he's allowed to have. And, you know, now the group home isn't getting paid. And, you know, people are upset. Christina's got to run around like a lunatic, calling a bunch of different bureaucratic agencies, trying to sort all this stuff out and get her brother back up on government assistance benefits and so on and so forth. So it's a mess, right? And the other thing that you need to understand is government benefits agencies, we talked about this in the last program and Don's program, they keep a lien. They keep a meter running of every dollar they spend on Jeff over the course of his lifetime, both Medicaid and DDD. And, you know, if Jeff's been living in a group home for the last 10 years, let's say the cost of Jeff's program has cost the taxpayers $100,000 a year to provide to Jeff. And I'm going to tell you right now, that number is low. That's an artificially low number. I mean, in today's dollars, it's costing about anywhere between $125,000 to $200,000 on average to provide residential services and supports to an individual on an annual basis. And in some cases, depending on the level of need of the person, it can be even higher and much higher. So they keep a meter running, and it's a surprisingly accurate meter, right? So let's say in my example, you know, Jeff's been there for 10 years. He's got $100,000 a year. He's got $1 million governmental lien, right? The government can come in and go, thank you very much, Jeff. We're going to exercise our lien now. We're going to take that $500,000 that you've just inherited from your dad. The good news is now you're eligible for SSI, Medicaid, housing assistance, DDD, and all those other good, you know, and vital means-tested government assistance benefits. The bad news is I've just now given a very large gift to the government. So not the best result in the world. So let's talk about this then. Sometimes I get people come in, they think they're really clever. They're like, I got an idea. Listen up, Baldy. I've got something I can do. I'm going to draft a will, and I'm going to leave everything to my daughter, Christina. I'm going to leave all of my estate, 100% of it, to Christina. And I say, Christina, you know half of this money is for your brother, right? Right, no, right, right.
Is it?
You're going to do the right thing, aren't you?
Of course.
Right. So I want everybody to look at their computer monitors right now, and I want everybody to take a really good, hard look at Christina. Who here trusts Christina?
Wait,
I don't.
Don't do it.
I'm sure, right? And worse yet, who here trusts that guy she married? right? That's got her doing all kinds of things that my little girl never did when she was mine, right?
Kinds of stuff.
Son-in-law, I begged you not to marry, but you did anyway, right? All right. So, you know, what can go wrong there? I mean, you know, certainly absolutely nothing, right?
Nothing for me.
Nothing for Christina. Again, notice how it all seems to be going back to Christina. Poor Christina. You know, I got to say, like, Christina's put in, Christina's sort of like the brains of this entire conference. She's the person who's logistically done everything for this conference. She just so happens to be, you know, sitting in and hosting my workshop right here by the luck of the draw. But she's put in like hours and hours and hours of work to pull all of this off. And now I'm picking on her. So, but you know, this is the price of fame, Christina. You know, I give this gift of what we call a gift of moral obligation to Christina. And she, you know, maybe she'll do the right thing. Maybe she won't. You know, I know Christina. I know Christina would do the right thing. I do. You know, so we've got to give her those props. But, and I know her husband would do the right thing too. That, you know, I got to say. So, but, you know, Christina, no, we're not going to do that for purposes of this illustration. So, you know, look, the reality is maybe Christina will do the right thing. Maybe she will obviously look out for her brother and make the funds available for the benefit of her brother, Jeff. And, you know, everything will be fine. And it will be exactly as I had intended it to be. And I don't mess up Jeff's government assistance benefits, but maybe Christina won't do the right thing. And then you got to think about the other things that don't, you know, that you have no control over after you die. You know, what happens if Christina passes away, you know, prematurely, or, you know, certainly before her brother? You know, those assets that I've given her, you know, they're part of her estate now, and maybe they go to her spouse, or maybe they go to her children, or maybe they go wherever, you know, and maybe her spouse doesn't have the same emotional and familial connection to Jeff as Christina does. That doesn't make him a bad guy. It just makes, you know, it's, you know, human nature. Maybe Christina's spouse does have a very strong bond and a commitment to Jeff as his brother-in-law. But, you know, if Christina's young and she passes away prematurely and her spouse, you know, her husband, you know, finds somebody else as a young man, as well as he likely would, you know, and he moves on with his life, you know, maybe that person is unlikely to have the same level of commitment to, you know, Jeff. And, you know, time moves on and commitments fade over time. And that doesn't make Christina's spouse a bad guy. It just is human nature. What happens if Christina and her spouse get divorced? If she finally wakes up and says, thank God, she finally left the guy. You know, if the money is in her name, you know, depending on a variety of circumstances, you know, that money may be subject to equitable distribution in the event of a divorce. At a minimum, it's something for two divorce lawyers to fight over, you know, in those circumstances. What happens if Christina, you know, is texting on her cell phone while she's driving one day and runs over a pedestrian in the crosswalk, right? And, you know, the limits of her auto insurance aren't enough, and they break through and, you know, goes after her personal assets. So there's all kinds of bad things that could happen. Taking away the possibility that Christina may just simply steal the money, right, and not ever spend it on her brother. There's all kinds of things that could happen that I have no control over, that Christina has limited control over, that could negatively affect Jeff. So, as clever as that person may think they are, it's not the best result in that circumstance either. So, what we do in those circumstances, and for folks like Jeff, is we want to make sure that we are able to segregate Jeff's money, put it in a form that doesn't disqualify him for government assistance benefits, but allows him to have the value of his government assistance benefits too, and the value of his inheritance too. So what we do in those circumstances is we create a will and we say, look, when I die, divide my estate equally between my children, give Christina her half, you know, good luck, right? Still never called me on Sunday. Forgot to send me a Father's Day card. But, you know, give money to Christina. She's got her half million. She's yippee skippy off into the sunset. The other $500,000, instead of giving it to Jeff, we put language in the will, instead of giving money to Jeff directly, we instead take that money and put it over here in what is commonly referred to as a third-party special needs trust. It's a trust that's allowed by the law to receive the value of these funds, to have funds set aside for Jeff. It does not, that trust contains language which prevents the trust from being counted as a resource by the government. It locks it up and says, look, the money in this trust is beyond the view of the government. The government can't look at it. Whatever is in it is whatever is Jeff's, but we don't look at it as a resource. Allows Jeff to stay on SSI, Medicaid, DDD, housing assistance, food assistance, utility assistance, all of the network or patchwork quilt of government assistance benefits that come into play for a person with special needs. So it's the device that's created as part of an overall comprehensive estate plan with wills and maybe tax planning issues and issues with minors trusts, which we'll talk about in a minute, and a comprehensive set of estate planning documents that comes as a package to make sure that when the inevitable comes for me, in my example, Jeff isn't, out in the street, and Christina hopefully has an orderly set of instructions to follow that are much easier to follow, that shows she can wrap up the affairs of my estate and make sure her brother is protected. Okay, so I'm going to talk in a little bit more depth here in a minute about the trust, about some other things. But Christina, are there questions that have popped up at this point? So if there are, I'll take them.
So I've got two questions. And it's a 1-2-part question. Who manages the third-party special needs trust, and how do we know that money is safe from the designated manager?
How do we know what?
The money is safe from them.
Oh, safe from them, meaning that the trustee doesn't steal it, right?
Right.
All right, so good. That's a great question. So let's talk about, a trust, just generally. So what is a trust, right? Let me tell you, it's kind of a nebulous concept, right? A trust is not some, fancy mahogany floored, marble paneled, financial institution. It is not some mysterious account at a bank. A trust is nothing more than a piece of paper with words on it. That's a trust. Some bald-headed lawyer or some other type of lawyer writes up a document, writes up this piece of paper with words on it. You as the parent sign it. Bam, a trust springs into existence, right? A trust has three main actors, okay? What are called a grantor or a settlor, right? Because lawyers have to have fancy names for things to make ourselves sound really important and learned. So grantor or settlor, that's the person who creates the trust. In my example, that's me, right? It's the parent, is the grantor of the trust. A trust has a beneficiary. That's the person who the trust is for, who the money is to be used for and spent on. In our example, that's Jeff. And a trust has what's known as a trustee. That's the third main actor. So to the question, who's the person in charge of this thing? Who's the person who manages this thing? That's called the trustee. That can be whoever I appoint when I create the trust agreement and I write down, on this piece of paper who I want the trustee to be. That could be Christina. Right? That could be a bank or a financial institution. That could be, some other family member or friend. You can have more than one trustee. It could be Christina, and my cousin Vinny, who serve as co-trustees together, right? You want to appoint somebody. The qualities of a trustee is, you want to be able to trust them, right? Hence the name, right? To the second part of the question is, who oversees the trustee? Well, that depends. That's a good lawyer's answer, right? That depends. On a lot of trust agreements, maybe no one's overseeing the trustee to make sure that the money is being used, isn't being, used for purposes other than for Jeff. But if you have co-trustee situations, that obviously, you have two sets of eyes overseeing the situation. If you have a trust company, those guys, or a financial institution as serving as trustee, those entities are usually bonded and insured to ensure that if there's any, nefarious or illegal conduct, that, Jeff's trust is, made whole again. Sometimes you can appoint what are commonly referred to as trust protectors. So Christina may be the trustee, but a trust protector, something like a law firm or an accounting firm, would have to review the document or review the financial statements of the trust on an annual or every other year or every 5-year basis to make sure that Christina isn't, skimming the money off the top for her own purposes or whatever. So there's a lot of different methods or mechanisms by which we could oversee, Christina's, if she were the trustee, to oversee her use of the trust. My general advice to families, however, is if you have concerns about the ethics of your trustee and about the morals of your trustee, I wouldn't be appointing a co-trustee. I wouldn't be appointing a trust protector. I wouldn't be appointing a bank or whatever to serve along with her. I'd be looking for a completely different trustee other than Christina, right? Because you just don't want that person around. I will say this to the question of, who oversees this. I get this a lot. I get this a lot in these types of forums. And I can tell you this, and in the course of my career, I have only been involved in 2 circumstances where the trustee was doing something that was completely untoward or, nefarious, right? And I've done thousands of these, and I've been involved in thousands of these. I can't even count anymore how many that I've been involved with. Am I naive enough to think that there aren't others out there that I haven't been made aware of or I'm not aware of yet? I mean, no, I'm not that naive. I'm not that dumb. I'm sure there's others, but there's only been 2 in my experience where the trustee really has done some pretty shady or bad stuff. And I think firm-wide, I could probably count on one hand how many people, how many circumstances where the trustee was doing some shady business. So it's less common than you think, but if you have concerns or if it just lets you sleep a little better at night, there are mechanisms in place that you can use. Christina, are there other questions?
There are.
Go ahead.
Does Christina get the money from the trust if Jeff passes away before her?
Oh, wow, we're jumping way ahead. That's a good question. That depends. Again, another good lawyer answer. It depends how nice Christina was to me, whether she did visit me in the nursing home, whether she did call me on Sunday, whether she did make my favorite dish for my birthday, etc. So it depends on it's a great question, and it's definitely something you want to think about. Who gets the money in Jeff's trust when Jeff goes the way of all living things, right? No one likes to think about their child passing, themselves passing away, much less their child, but, look, none of us are immortal. It's a great question. When Jeff passes away, I get to decide. I get to write into that piece of paper with words on it. I get to write in to that document where I want the money to go when Jeff passes away. Now, yes, probably the most common thing to have happen in a scenario where you have a child with special needs and neurotypically developing children is that the money, and if it's left over, goes to the neurotypically developing children, or in this case, child. And if she's not living, then it would go to her children, my grandchildren, right? That's common. That's a common way that most, I would say 90 to 95% of all parents elect to set up who gets the remainder when Jeff passes away. And that's a good thing to do. However, you can also leave money to charitable entities if that's what you wish. Other family members, if that's what you wish to do. You can leave it to Christina and I. We'll take it. Don't worry, we won't tell anybody. It's your secret safe with us. And as you have found out, Christina will absolutely take it because she's trying to get her hands on it this entire day. But sometimes leaving money to charitable entities when the child with special needs passes away is a nice way to say thank you. A lot of times what people will do is they'll say, leave any money that's left over to those nonprofit agencies, excuse me, that have served my son over the course of his lifetime, in the discretion of my trustee, which is a nice way to say thank you, to the nonprofit entities that have supported and served your son, in this case, my son, over the years. So, there's no real limit to what you can do, or you can do both. You can leave some to Christina and some to, the program that has served Jeff over the years. There's nothing stopping you from doing any of that stuff, but it is something you need to address. And that's something when I sit with a client and, I go through, my interview with them, I ask them directly, where do you want the money to go if there's anything left over when your child with special needs passes away? So, other questions, Christina?
Yes. Your firm prepared a special needs trust for us years ago. Should we assume it was a third-party special needs trust? Have the rules changed in recent years?
How many years ago?
You just said years ago.
Oh, years ago. Well, no, I mean, I don't know if it's, I think it's probably, if it was set up by one of us in the context of creating wills and durable powers of attorneys and medical directives and so forth, it's probably a third-party trust. But that doesn't mean, I don't know who you are. I don't have your file in front of me. I got to, I can't say with certainty, but it's probably a third-party trust. But let me say this about estate plans, whether it's estate plans that are drafted by this office, another office, whether an estate plan is drafted because you have a child with special needs, or whether you have, just only neurotypically developing kids. Estate plans are living, dynamic things, right? You're never really done. The only time you're done with your estate plan is when you die, right? And then, then you're done because you're done with everything. So estate plans have to be checked in on, and they evolve over time. Things change, circumstances change in your life, so forth. Look, the law surrounding third-party special needs trust hasn't changed in 20 plus years, 30 years or so, maybe even longer. First-party trust situations, there's like minor tweaks in the laws over the years. So if you did a third-party trust, 20 years ago, it's still going to be good today. However, is that trust going to be, from a benefits preservation point of view, it's going to work? But is it going to be the best trust? No, probably because, service delivery systems have changed. The way government does business has changed. So having documents in place that account for that is I think, important. And look, the practical matter is people in your life change. When you appointed your brother, Bob, and your sister, Sue, as the trustee of trusts, when you were in your 30s, and now you're in your 50s or 60s, and you've got grown children, you probably want to appoint them, instead of your brothers and sisters. So, you got, what I say to families is I want you to look at your documents at a minimum every 3 to 5 years, or at a maximum every 3 to 5 years. Once you open them up, once you look at them, make sure you're still in speaking terms with the guardian of your kid, right? Make sure the person who's serving as trustee of your trust is still alive, right? Make sure you still know the executor of your estate. If you did your documents a couple years ago and you're still in speaking terms and everybody's still around, they're probably good to go. You can probably put them back in the drawer and they're fine, right? However, it's a good idea to have your estate planning documents and overall estate plan at least briefly reviewed, professionally, every 5 to 10 years, right? Some people go longer. I got people who come back who say, they did their documents with somebody in the office 20 years ago. That's fine. You're still alive. There's nothing that's done today that can't be undone tomorrow. I can't tell you, I've had a number of occasions over the years where client would get their documents, they sign the documents, and a week later they call them up and they say, what was I thinking appointing my brother Bob as the trustee of my kid's trust, right? And we can always change things as long as you're still alive. So, Christina, other questions?
Yeah, we've got quite a few actually, and they're getting fancy on us. You know who you are. What if the son lives at home and you leave him a house or a life estate in the house and he uses SSI/DIB to pay his expenses?
Yeah, now we are getting a little fancy.
Yeah.
Could you repeat?
I can't hear you, Paul. There you go.
I'm sorry. This earbud is dying. The battery is dying, so I put that earbud in. Could you repeat the first part of the question again?
What if the son lives at a home and you leave him the house or a life estate in the house and he uses SSI/DIB to pay expenses? Okay.
So you can all right, so let's talk about houses and trusts and kids with special needs. So, you know, because it's a great question. It's a broader, but it has a broader implication. Look, remember what I said before, a person with special needs can have no more than $2,000 in assets in their own name. One thing that's not actually considered an asset to a child is a piece of real estate. The piece of real estate that they live in, however. So yes, you can leave a home to a child with special needs. And if, as long as that child lives in that home, it will not be counted as a resource to the child. However, I don't advise it. Okay? Because the child has to continue to live in that home. My experience is almost universally is that if a child lives in that home, an adult child lives in that home, that child's needs are going to change over time. And depending on the nature of the child's disability, they may change drastically over time, and they also may change rapidly over time. And there may come a time in which that child can no longer safely or effectively reside in that home. So Jeff, I set him up, I bought him a house, I gave it to him when I died, or I gave it to him when he was alive, and I titled the house in his name. Jeff lives there hunky-dory, he's getting along just fine. He's got staff to check on him and help him out from time to time. But then, Jeff gets a scary diagnosis that has nothing to do with his underlying disability. Jeff gets older and more infirm, and he can't stay there anymore because his needs have now outstripped his independent living arrangement. And maybe he now has to move in, or maybe Jeff becomes more behavioral over time. Maybe Jeff goes into crisis when I die, and he can no longer be safely managed, in a more independent and lessly monitored living arrangement. And Jeff's got to leave that home. He's got to go somewhere else. He's got to go to a nursing home. He's got to go to a typical supervised apartment, or he's got to go to the typical suburban-based group home. Now Jeff's no longer residing in that house. Guess what happens? That house becomes a resource to Jeff. All right, and Jeff's now got Christina has got to get that home sold. She's got to take the proceeds of that sale. She's got to try and keep it out of the clutches of the government. She's got to try and park it in a first-party special needs trust where the government's going to have a right to claim the money when Jeff dies. So it's not a good idea. What you generally want to do is you want to park the trust in a piece of park the real estate, in a trust, and have the real estate titled in the name of the trust. Jeff can still live there, but he doesn't own the house. It's not a resource because Jeff doesn't own it. It's not a resource because it's in a trust. And if Jeff leaves that house, then the house remains in the trust. Christina can sell the house, take the net proceeds of the sale of the house, keep it in the trust in the form of cash, right? When you have a piece of real estate in a trust, however, you do want to make sure that there's enough money in the trust, enough cash in the trust to also pay the carrying expenses of the house, the real estate taxes, when it needs a new roof, when it needs new windows, when new air conditioner, all that good stuff that are associated with pieces of real estate. You want to have the real estate and enough cash to carry it. So that's the cleaner, easier, better way to handle it. Now, when you talk about life estates, right, now that is really, that comes up, and that's also possible too. I give a life estate to Jeff and a piece of real estate. I'm not going to go into what the details of a life estate are because we spend like a day on it in law school, and then you don't understand it anyway as a law school student. But a life estate basically, in the thumbnail term, is that I can give the house to Christina, but I can let Jeff live there for the rest of her life, and she can't sell it out from under him. Okay, I don't advise that either, because then Christina becomes responsible for a lot of the expenses of the house, and she's going to get pissed off at her brother for living there, and she's got to, have the maintenance and upkeep on it. And then life estates, depending on how young Jeff is when I die, life estates have values. They actually, Medicaid deems a value to a life estate. If you're 95 and you have a life estate and an elderly adult, it's almost worthless. If you're 35 and you have a life estate, it's going to be valuable, because we take Jeff's statistical life expectancy and we give an annual dollar amount to that. And that's probably going to, at 35, that's probably going to be in excess of, the value of his life estate is going to be greater than $2,000. So it's generally something I don't advise.
Does it make sense to fund the trust while I'm alive, and what are the tax implications, if any?
There can be tax implications depending on what you put in it. Remember, trusts are taxable entities. Trusts have to pay taxes. And trusts are, generally speaking, taxed at the highest possible tax rates. So, and now trusts are only taxed on the gain, in a trust. If I put $100,000 in a trust, that's not a taxable event. It's any interest that $100,000 earns over time becomes taxable. And trusts are taxed at a rate of 39% on the gain, which is a really high tax bracket. Now, I'm not going to get into all the nuanced tax implications. There's ways to reduce that tax liability. And there's, very effective ways to reduce that marginal rate down to much lower numbers, but they get a little more complicated, and I'm not going to address them in this type of form because, they're very complicated. And they're very particularized. The answer for one person is not the answer for another person. However, you can put money in a special needs trust in your lifetime, a third-party special needs trust in your lifetime. And that may be good if you have, quote, excess wealth, or you want to ensure that there's money set aside for Jeff, when you die. However, the practical thing you need to understand is once you take money out of your pocket and put it into a trust for Jeff, that money is irrevocably assigned to the trust. I can't get it back. So if I have my own needs, my own expenses, my own long-term care needs, et cetera, and I want to get that money back to spend it on me, I can't do it. I can use the money for Jeff's benefit. I can spend the money on Jeff, but I can't spend it on me. So, I generally suggest to families, you want to fund, if you're going to fund these things during your lifetime, you're going to fund them probably later in life as opposed to earlier in life, because you don't know what tomorrow is going to bring for you. Christina, other questions? I'll take a couple more, then I'll launch into some things.
Is there a guide slash how-to book on how to be a trustee of a third-party special needs trust?
Not that I'm aware of, although maybe when I retire someday, I'll write one. Like an idiot's guide to special needs trust administration, but I'm not aware of one. I'm not saying there's not one out there. There's none have ever been called to my attention. Generally speaking, what folks do is when they, look, all the time, I get somebody across my desk whose parent or parents have just died, and they're the sibling. They're Christina, in my example, right? And they're looking at me going, what the heck do I do with this, right? What is this mind-numbing document? My parents never talked to me about any of this stuff. I have no idea or no clue what benefits my brother's on. I say, is your brother funded by DDD in a group home? And they look at me and go, DD what? Generally speaking, guys, I don't clue Christina in, neurotypically developing children in as they get older. Let them be kids, but when they get older, you do want to kind of keep them involved. But even if they are involved, they don't really understand the nuances of a special needs trust administration. I will say this. I talk to them, we talk to them, we kind of give them, the pointers and the how-to guide from just talking to them about how you administer these things, and they get it. And then they call back 2 weeks later and say, what did you say again? Or, they call back a few months later and they say, well, I'm about to make a distribution, I just want to check in before I do it. And you answer the questions. And then over time, they begin to intuit, and they begin to wrap their mind around the administration of a special needs trust. It's not particularly hard. It does require some work. It does require a certain way of thinking, but it's not particularly hard. You don't have to be a financial whiz. You don't have to be an accountant, a financial planner, or a lawyer to do it. Anybody can do it. You just have to have a person who's reasonably diligent, obviously honest and trustworthy, and is going to keep reasonably diligent records. And of course, most importantly, look out for the brother. So, all right. Other questions? One more question. I'm going to move on to.
What happens when the special needs trust gets the proceeds of an insurance policy?
What happens when the special needs trust
gets the proceeds of an insurance policy?
It gets the proceeds of an insurance policy?
Yes.
Yeah. So again, that's a funding. So what happens is someone has died, obviously, and an insurance policy is paid into a special needs trust. Now remember, as part of an overall estate plan, part of the estate planning process is going through people's insurance policies, IRAs, 401ks, things that have designated beneficiaries associated with them. We got to make sure that the beneficiaries are lined up with what our overall wishes are, right? So we don't want to have a life insurance policy or a 401k we forgot about that says, you know, upon my death, leave my 401k or my life insurance to my kids or to my issue or to my heirs at law, or all those things that you set up and you wrote down the beneficiary designations 20 years ago or 20 years before Jeff was born, and you never got around to looking at them. So you have to adjust your beneficiary designations and all these things to make sure that they align with what we're doing and you don't undermine what we're doing. But one of the ways we do that is to say, look, I got a life insurance policy. Let's say I have two life insurance. You know, what I say, I had $250,000 worth of life insurance. You know, let's say that policy, I can say the beneficiary designation is 50% Christina and 50% the Jeff Harris Special Needs Trust of 2020. Okay, so I croak. That's the legal term of art for it, by the way. I croak. Christina gets half the life insurance immediately. Jeff's trust gets the half the life insurance immediately as well. And it's a good thing because I've immediately put liquid assets in Jeff's trust because life insurance pays out pretty quickly. It's all in cash. It's not taxable from an income tax point of view. It's just bam, cash goes in the trust right away. Christina can be using that money while the rest of the estate is being probated, to provide for Jeff's needs, and all is right with the world. So life insurance is a quick, easy, clean, effective, in some ways, many ways, tax-advantaged way to move money very quickly into a trust at the greatest time of need, meaning when I've died and I'm no longer able to provide directly for Jeff's needs. So, I highly, look, it's like building a bar stool. There's no such thing as a one-legged bar stool. You fund a trust with a variety of different mechanisms. Life insurance is one of them and is a very effective and important way to fund a special needs trust. But that doesn't mean when my estate is liquidated, my home is sold and the claim is made for my 401k or, my stocks are rendered or, redeemed or whatever, that those assets also don't go to a special needs trust as well. Okay. So let me move on a little bit. I'll come back to some more questions, but let me move on a little bit and talk about probably what's already in the question box. And it always comes up is, all right, I got this trust and I've got $500,000 in it and it's there for Jeff. And, I got Christina and she's running the thing and, Christina's all right. She can take care of it. And, what do I spend the money on? Like, what is this money used for? I got this money set aside for Jeff. So what do I spend it on? How do I spend it? Right. Again. So, remember in my example, and this is the common example, Jeff is living in a very typical, stereotypic suburban-based living arrangement, a group home. And he has been for the last decade, and he likely will be there for many, many more years to come. All of Jeff's basic lifetime needs are provided through government assistance benefits, through SSI and Medicaid and DDD, and other forms of government assistance benefits that are paying for the lion's share of Jeff's daily needs. But they don't cover all, as good as a program might be, it doesn't cover all of Jeff's needs or wants. So we want to have this trust set aside to supplement what Jeff requires or what we would want for Jeff. I'm calling this type of a trust, just as part of his estate plan, a third-party special needs trust. Some other practitioners, they refer to this thing as like a supplemental benefits trust. Different practitioners use different names for things, but it's all the same thing when we're talking this context. I prefer to sort of refer to as a trust with a few limitations, or a disability trust with few limitations, so that the money can be used for the benefit of the person with disability. So in our example, Jeff may, well, let me back up. I think it might be easier if I do this. You know, as many of you probably know, I have an older brother with autism. He is pretty profoundly affected. You know, he's nonverbal, virtually non-communicative. He needs assistance with all his activities of daily living and so on. He lives and has lived for the last 20, 25 years in a very typical suburban-based group home. He's got an excellent provider agency. You know, we're very lucky. And he has a very rich life within the limits of his disability that are all provided by his program. But for COVID, I would say he has, generally speaking, has a better social life than I do. If this was a typical Saturday morning, he'd probably be out doing something in the community, you know, or going somewhere, you know, et cetera. You know, I'd be standing here in my office, or I'd be standing here probably in person talking to you guys. So he's got a very, very rich life within the limits of his disability, and very grateful to his provider agency for doing all that. But as good as that provider agency is, and for as many hundreds of thousands of dollars or millions of dollars he gets spent on my brother over the course of his lifetime, there are still gaps that need to be covered. And there still are the fun things that aren't covered through government assistance benefits agencies. So for instance, my brother's been on 2 Caribbean cruises with his housemates and his staff, okay? That's not covered through government assistance benefits, I assure you. Again, but for COVID, generally they go away for a week in the summertime, sometimes down to Ocean City, Maryland, or Ocean City, New Jersey, or somewhere on LBI, or you know, whatever. They take a nice summer vacation. Sometimes they take a little winter weekend away, or they go out for trips, excursions, you know, dinners out and so forth, and, you know, community awareness and so on. You know, all that stuff. None of that stuff is covered through government assistance benefits. Sometimes my brother needs, you know, an upgraded, you know, mattress or personal items for his room, or, you know, exercise equipment, or, you know, other tangible items or services that aren't covered through government assistance benefits. Now, you know, my parents are still alive, and they have the good fortune of being able to, when those kinds of things come up, they can reach into their pocket and cover those expenses. But when they die, a trust will be funded, of which I will be the trustee, that will allow me to continue to pull money out of the trust to provide for those kinds of things, you know, all those things that aren't provided through government assistance benefits. A person with a disability should not have the fullness or the richness of their life compromised or curtailed merely because their parent died, right? We want our children, probably after we're gone more than ever, to be able to experience the fun stuff and the supplementals in life, to have as rich a life as possible. So that's precisely the time where we want those trusts funded, and we want them to be used for those purposes. Now, you know, look, my brother grows older. You know, we may be using the money in the trust not only for those fun things, but there are sometimes, you know, circumstances where we have to pull money out of the trust and pay for things to allow, you know, him to age in place, you know, such as architectural modifications to the group home he lives in. If his mobility is compromised, it has nothing to do with his underlying autism, but allows him to remain in his home that he will, by that point, probably have lived in for 30, 40 plus years. And we want him to be able to age in place. So maybe we need to, you know, make more architectural modifications to doorways or entryways or bathrooms or whatever. And government assistance benefits might cover some of that, and grants might cover some of that, but they might not cover all of that. Accessible vehicles, durable medical equipment, second professional opinions. You know, Medicaid will pay, or, you know, insurance will pay maybe for one opinion, but they don't always pay for or they don't usually pay for second professional medical opinions. Alternate treatment, experimental treatment, you name it. Maybe I want to have the ability to bring in additional staff, or to provide for supplemental staff beyond what the government will provide, because maybe his needs exceed what his provider agency is able to provide with the staff that they have. Specialists, specialized clothing, you know, I think I said before, accessible vehicles, you name it. Now, those things aren't fun to think about, But remember, a lot of times, as people with disabilities live longer, they encounter the same medical and aging conditions that we all face. And sometimes those things outstrip or exceed or eclipse the needs of the underlying disability. So you're going to want Christina, or, in the case of Jeff, or me, in the case of my brother, to be able to pull money out of a trust to pay for those kinds of things that allow, Jeff or my brother or whomever, to allow your child to have an easy and happy existence as possible long after we're gone. And it's a great way to leave a legacy and to leave a safety net, for our loved one when we're no longer here. It's easier. So that's commonly what we would say that you spend the money on. It's actually easier to kind of talk about what you can't spend the money on. You can't spend the money on, Christina in this example cannot take the money out of the trust to pay for things that are provided to Jeff by the government. You cannot use those things to pay for goods, items, or services which are otherwise provided through government assistance benefits, which sort of makes sense. If the government's paying for something, why would you pay for something? But you can use the money in the trust to enhance or supplement or augment what the government is giving, but not replacing what the government provides. So that's sort of the answer on how you, or that's sort of the thoughts I have on how you use the money in the trust for the benefit of the person with special needs. Christina, are there any questions about that stuff or others? You're muted.
I know. Okay. So I've got others. Once third-party trust becomes irrevocable, can I change designated trustees on my will? Third-party trust is about to be funded by my ex-husband's IRA distribution. Can I then fund it with my own money while I'm alive? So I guess that's a two-parter.
It's actually a multi-parter.
Oh, yeah.
Whether the person knows it or not, that's a multi-part question. Well, I don't understand all the background of it, and things in the law and answers in law can sometimes change 180 degrees based on the smallest facts. But making some assumptions about the answer to the question. First of all, the trustees of a trust are not named under a will. They're named in the trust agreement itself, right? The trust agreement, that piece of paper with words on it, says a whole bunch of things, including who's the trustee. When a trust becomes irrevocable, no, you can't change the trustee. You can't have a letter, you can't have a appointment in a will. You got to change the trust agreement itself. But if the trust is irrevocable, you can't change the trust agreement because it's, irrevocable. If you have a trust that's revocable or revocable, you can change it at any time. But you can't change a special needs trust if it's irrevocable. Special needs trusts are irrevocable under one of two circumstances. Either the plain language of the document says this trust is irrevocable, or, well, actually three circumstances. The plain language of the document says it's irrevocable, or the person who creates it, the grantor, dies, or the trust becomes funded. If there's money in the trust, then it's irrevocable. So, no, you can't change it. Now, yes, you can go ahead and if you wanted to, if it's your ex-spouse's IRA that's going to go into this trust, if you want to put money in this trust, you certainly can, but the question seems to indicate we want to change trustees, so I'm not sure you want to put your money in a trust where you don't want the trustees, you don't like the trustees, or you want to change the trustees that are currently named. Now, what often happens, let's not get too excited or too worried here. What often happens is, maybe we created this third-party trust a bazillion years ago, and it's your brother Bob and his sister Sue that are serving as trustees. And maybe they don't want to serve as trustees. Maybe they don't need to serve as trustees. Maybe they were appointed as trustees because when you set this thing up, your kids were little, right? And now they're grown, right? And you maybe want to make your neurotypically developing kids the trustee of that trust, but that trust is irrevocable. My experience with that is like brother Bob and sister Sue are really happy to resign. You know, a trustee can resign at any time, and they can sort of quit, you know, under the circumstances that, hey, it's fine, we don't need to do this. We'll resign, and we will appoint, you know, your neurotypically developing adult children now as, you know, we will nominate your neurotypically developing adult children as the trustees. That happens all the time in the cases where irrevocable trusts are funded or they've become irrevocable, but everybody sort of agrees what we may want to do. Now, you're talking about your ex-spouse, so, you know, to speculate here, and just only to speculate and use it as an example, if your ex-spouse has named his brother Bob and his sister Sue, and they don't want to resign because they want to control the money because it's from his IRA, and you'd rather have it be, you know, your brother, you know, Barry and your sister Sarah, you know, Bob and Sue may say, you know, go jump in a lake. We're not resigning, and there's nothing really you can do except create your own third-party special needs trust and fund it, you know, with the proceeds of your own estate when you die.
Can/will the individual's survivor SSD be able to go into the special needs trust?
Wait, can what?
All right. Can/will the individual's survivor SSD be able to go into the special needs trust?
Oh, all right. So, right. So mom dies or dad dies, and there's a survivor's benefit that's on a monthly basis based on mom or dad's social security number. Okay. And the question is can that monthly income benefit go into a third-party special needs trust? The answer is no. You cannot do that because the survivor's benefit is the child's money. You cannot put the child's money into a third-party special needs trust. You can, however, put the child's money into a first-party special needs trust. It's a different kind of a special needs trust. All this time we've been talking about what's commonly referred to as a third-party special needs trust, or sometimes called a supplemental benefits trust. If you're taking the child's money from a survivor benefit or an improperly received inheritance or medical malpractice issue or whatever, you know, or a type of settlement case, those funds that belong to the child have to go to a first-party special needs trust. And the difference is where does the money come from? Does the money belong to the kid being the first party, or does it belong to somebody else, like mom and dad or grandma and grandpa or whatever, because it's a third party, goes directly into the trust. The difference between the two types of trust is what happens when the child's special needs dies. All right, in a third-party special needs trust, the money goes back to goes to wherever we want it to go. In a first-party special needs trust, the money goes back to the government. So we can take Jeff's survivor's benefits if we want, or we can take improperly received inheritances, or we can take, you know, the proceeds of a lawsuit that he might have down the road from an automobile accident or whatever, and we can park it into a first-party special needs trust. But when Jeff dies, the money's going back to the government. So you cannot, and under any circumstances, take the money that belongs to the person, whether it's from an automobile accident or a medical malpractice case or government benefits that are his, and put it in a third-party trust, because if you do that, you're going to end up tainting the well, so to speak, and you're going to subject all of the assets in the third-party trust, and you're going to subject it to a Medicaid or a governmental clawback. So don't do that. Okay? Christina, next question, if there's any.
I've got, if Jeff's grandmother leaves money to his trust, is that taxed?
Oh, no, well, probably not, depending on where Jeff's grandmother lives when Jeff's grandmother dies. So there's no income tax to Jeff or income tax to the trust when grandma leaves money to Jeff's trust. In New Jersey, there'll be no estate tax. If grandma dies and she's a resident of the state of New Jersey, there won't be any estate tax. There won't be an inheritance tax. If grandma lives in Florida or in Pennsylvania or in some other states, by way of example, there might be an estate or inheritance tax on grandma's estate as a result of that gift. But generally speaking, you know, it's probably in most circumstances not going to be a taxable event. And I will say this, by the way. There's sometimes you just can't avoid tax. There's two things certain in life: death and taxes. And this is everything all in one.
And this will probably be our last question, I think. What if somebody doesn't have anyone to appoint as either after they die, or if they don't have any backups?
Right. Good question. Happens a lot. So right, Christina's not. There was no Christina. It was just Jeff, or Christina. Just as I said before, really isn't trustworthy. We can't appoint her. There are some options. People can use like a bank or a trust company to serve as trustee, like a financial institution, something that's permanent, or they can use what's commonly referred to as a community trust organization. Organization like Plan New Jersey is a good example of a community trust organization. They presented yesterday morning. They can serve in capacity as trustee, and they can manage these funds in the event that you have no one that you can use as trustee, or no one as a backup. Maybe I named Christina, but she is my only other kid, and if something happens to her, I would maybe appoint Plan New Jersey as a backup to her to take over in the event that she predeceased Jeff or somehow died prematurely. So that's kind of what the kind of thinking that you want to engage in those circumstances. Christina, any other questions?
I think you touched on this a little bit, but can special needs trust funds be donated to the provider agency?
After the primary beneficiary has died, sure, right.
And then if both parents die, do the child still receive SSDI benefits?
Yes. Well, it's not if both parents die. It's when one parent dies. When the first parent dies, or the first parent retires and starts drawing Social Security benefits on their own work history, or if the first parent becomes disabled and starts drawing SSDI because of whatever circumstance. Yes, then the adult child is going to receive SSDI under the parent's work history. The difference is that when a parent retires or goes on disability themselves, the child with special needs gets 50% of the maximum benefit of the parent. It doesn't mean the parents goes down. It means that they get, if the parent was getting $2,000, the kid will get $1,000. And what will happen when the person dies, the kid will go from getting 1/2 of the parent's benefit to 3/4 of the parent's benefit. Okay. One thing I do want to touch on very, very quickly in a couple of minutes is remember that these documents are also used as, these estate planning documents are also used as an opportunity to appoint a successor guardian to yourself in your will. And that's something you want to make sure you do. That's a very fundamental part of this overall estate planning and long-term planning process. You absolutely want to use this document to appoint one of you, if it's a brother or sister, niece or nephew, adult, typically developing child, as the guardian of your adult child or minor children. Look, I die, I'm Jeff's guardian. If he's an adult under guardianship, and I became his guardian years ago, I can appoint and nominate Christina as the backup guardian to me, so she can be the guardian for Jeff after I'm gone. If Jeff is a minor, right? If we did this years ago, and Jeff and Christina are both minors, I can appoint my brother Bob or my sister Sue to be the guardian of both my minor children. The difference will be when when Christina turns 18, she doesn't need a guardian anymore, and she's she's an adult in the eyes of the law, right? In air quotes, right? Jeff, when he becomes 18, my brother Bob or my sister Sue will have to go to court to be appointed Jeff's guardian, because he will be an adult, and somebody will have to be appointed to be the guardian when he becomes an adult. But it's a way to nominate a successor to yourself, to make sure that Jeff has someone to look out for him and speak for him and protect him, from the world, if Jeff is an individual that can't manage his affairs and govern himself independently. So I'll just leave you with that thought. Christina, any other last minute questions? If not,
can a group home organization be named as a guardian for our adult son? I don't know if that's...
Probably not. Probably not. I would say definitely not, actually. A provider who's providing services to your child cannot serve as guardian of your child. And just as a practical matter, even if they could, I would never advise it, just to be aware. Okay?
All right, well, I think that does it.
All right.
Thank you to everyone for joining. I thought your questions were really great today. We'll see you on the next workshops, hopefully.
Thanks, everybody, for coming. See you in the next workshop. Have a good day.
Thank you for watching this encore presentation from the Fall 2020 Hinkle, Pryor and Fischer Parent Empowerment Conference. With 24 other presentations to view, there is plenty of additional information to help you become empowered. As a reminder, the information contained in this video is not a substitute for individual legal advice and does not create an attorney-client relationship. Copyright 2020 Hinkle, Pryor and Fischer, PC, Attorneys at Law. All rights reserved.